All right, so you just had an opportunity to review the discovery with your attorney. You've had an opportunity to bring any motions to exclude any particular evidence that you believe needs to be excluded. What happens next? Dan McDermott here, McDermott Law Group, McDermott Mafia, McDermott Militia, all one of the same. Guys, this is part 12 of our series on self-defense for need to know what? Need to know the law. You have three different options at this point. First, you can enter into a plea, okay? That's where you negotiate a plea, negotiate a sentence, or your attorney negotiates a sentence on your behalf with the prosecution. If in fact you're amenable to that, you enter into a plea. In exchange of a plea of guilty, you go ahead and take whatever that sentence is. We're not in the habit of doing that, especially when it comes to self-defense cases, but it's ultimately up to you. Number two is a bench trial. You try your case in front of a judge. And number three is a jury trial. You try your case in front of a jury, which is what you typically see when you watch television or movies. You're in front of 12 members of your peers, or at least we're supposed to believe that they're your peers. And what I mean by that is you might be going through jury selection, which I discussed on another Need to Know, and you might not really believe that these people are really representative of your peers, but that is the system, that is the process, and that's what jury duty is all about. A bunch of random individuals show up, you get to ask them questions, you get to make a determination as to which ones you're going to go ahead and select and which ones you're going to try to avoid. You only have so many different peremptory challenges to avoid them. It's discussed in another video, but what I really want to talk about with respect to a jury is the significance of presenting your case to a jury as opposed to a judge. Sometimes you don't want to present your case to a judge because you don't believe that one person can be fair and impartial for whatever reason, or you don't want one person deciding your fate. You'd rather have 12 people deciding your fate. There are certain downsides with respect to going forward with the jury trial, and I just want to bring up two of those different downsides. One is that when you're in front of a jury, once you selected your jury, you are not allowed to tell the jury certain things during the course of your trial. For example, in most jurisdictions, and as far as I'm concerned, all jurisdictions, but you have to be familiar with the laws of your state, you're not allowed to tell the jury what the potential sentence of the crime is. So for example, if I'm arguing on a client's behalf for whatever the charges are, I can't tell the jury anything with respect to, hey, you know, what my client's facing is very serious. He faces between this many years and this many years in jail if in fact you convict him, because it gives rise to a lot of emotions. A lot of people don't want to hear that, and because of that, potentially could have an unfair advantage. The defense can have an unfair advantage when it comes to a trial. So the law specifically precludes the defense from doing that. And number two, which is basically related to that, is not only are you not allowed to tell them what the sentences are, but sometimes you run the risk with the jury to what I refer to as splitting the baby. What that means is they've been through deliberations. The jury's in day 2, day 3 of deliberations. Or, you know, maybe the trial ended on a Friday and they're 3 or 4 hours into the deliberations and they just can't seem to make up their mind because some of them say guilty, some of them say not guilty. You run the risk with the jury going ahead and saying, hey, let's split the baby, let's split the difference. Let's go ahead and we'll convict him on this particular charge, and we'll find him not guilty on this charge over here, or these charges over here. And how this usually happens is, say you've got a case where you fired your gun, you hit somebody with the shots that were fired. You're being charged with a whole bunch of different charges, but some of them are aggravated battery with a firearm, and some of them might be like something like attempt murder. Well, the jury says, well, attempt murder is obviously the more significant charge. Let's go ahead and find him not guilty on attempt murder for those people that believe he's not guilty, but we'll find him guilty on the aggravated battery with the firearm for those of us that find him guilty, and this way we can all go home. What does this mean, though? What does this truly mean? The jury never goes ahead and imposes a sentence. That is the job of the judge. So the jury doesn't even know what the heck the sentencing range is. They basically pass their verdict on to the judge. The judge reads it off, dismisses the jury, and actually it's passed on to the clerk. Clerk passes on to the judge, and the judge reads it off. But the jury is dismissed, and thereafter we have to go forward with the sentencing hearing in the event that there's a finding of guilty. Now, what many people know is battery itself, at least we're talking about Illinois for purposes of this self-defense series, a simple battery is punishable by up to 364 days in jail and up to $2,500 in fines. And generally speaking, most people receive supervision unless they have an extensive background. What's the significance of this? Somebody on the jury saying, hey, you know, aggravated battery with a firearm, it can't be that bad. It's got the word battery in it. My cousin was charged with the battery. He got supervision. But, you know, with respect to the attempt murder, that's very bad. I don't know what it is, but obviously it's very bad. Well, in Illinois, a simple attempt murder, and I say simple because there are multiple ways to charge these different offenses, but generally speaking, an attempt murder, before you start talking about enhancements and certain things that can tack on additional charges, is between 6 and 30 years. And when I say tack on additional charges, I mean tack on additional years. Typically, an attempt murder is 6 to 30 years. What do you think an aggravated battery with a firearm is? It's also 6 to 30 years here in Illinois. which means that this jury basically say, hey, let's split the difference here. We'll go ahead and find him not guilty of the more significant offense, and we'll find him guilty of the less significant offense. But in all reality, in this particular situation, this particular example, they're basically both punishable by the same consequences, the same time. What do you think of this, guys? Hopefully this is helpful. Talk to you soon.